And good morning, everyone. Thank you for joining our first RIPE Bite-Size session. My name is Rob Smedley and I work in the employment law team here at Freeths. And the first very important question we have received from people is, what on earth does RIPE mean? Well, it stands for Regulatory, Immigration, Pensions and Employment. We are all teams here at Freeths, or which are all teams here at Freeths, working together on people issues in the workplace every day. We thought it would be a good idea to try some monthly bite-sized sessions looking at hot topics across each of these areas, short sessions of around 15, 20 minutes, covering some key points before people get stuck into their days. So here we go. Here I am with session number 1, which is going to have a quick update on the Employment Rights Bill, which I would class as a rumbling hot topic. I'm sure you probably agree. Just to mention, each of you will receive a copy of the slides and the recording after the session, together with contact details if you wish to submit any questions, as Tom mentioned, plus information and a QR code about future sessions. Next slide. Thank you, Tom. So, Employment Rights Bill, we're nearly there. Many of you will have seen the news last week that the Employment Rights Bill is coming to the end of its journey. You'll also probably be aware that the House of Commons and the House of Lords have been debating the draft legislation for months, with amendments being passed backwards and forwards, some added and accepted, some rejected. The House of Commons rejected the recent non-government opposition amendments from the House of Lords, and the bill is now back in the House of Lords, waiting for them to agree or disagree with those rejections. Through parliamentary practice, it's almost certain that the House of Lords will accept the current position and approve the bill on the 28th of October this month. So we are very nearly there. Then the legislation will likely receive royal assent in early November, and some of the provisions will actually start to come into force this year. You may have also seen that the government had already published an implementation timetable which sets out the intended implementation dates for the various new laws under the bill, with different laws coming into force at different times over the next few years. The laws will come into force through different legislative means, such as new regulations or changes to existing legislation, such as the Employment Rights Act. As we know, some of the changes are significant, and before the new legislation introducing different parts is finalised, there will be, guess what, further consultation. Next slide, please, Tom. So I wanted in this bite-sized session just to touch on 3 of the more significant areas and areas which really remain quite contentious. The first one being day 1 unfair dismissal rights. Where are we at with this new law? Well, it's due to come into force, due to be implemented in 2027. So we have some time to prepare, but it remains one of the headline grabbing changes and one of the most controversial reforms. The government quite early recognised that it couldn't just have complete day 1 unfair dismissal rights. So it introduced this concept of an initial employment period, effectively a statutory probation period. But this remains not popular with business. A CBI survey from last month said that 86% of firms believe that the prospect of being taken to tribunal for dismissals during the probation will make them more cautious about hiring. So what are the key elements of this initial employment period or employment process, probation process? Well, it won't apply in relation to redundancies. So employees will have protection against unfair redundancy dismissal from day 1. The exact form of the probation process and the protections and related protections is not yet confirmed, but we anticipate it will be a mixture of a modified, or as the government calls it, light touch procedure that will have to be followed during that period if people are to be removed. It's likely to involve, no surprises, a meeting, an explanation of the decision by the employer. And if those processes are not followed, we're into unfair dismissal territory within that probationary period. Even though there's only reference at the moment to a meeting having to take place and explanation, it's obviously going to be good practice to use documents, an invite letter, and a record of the decision to help protect employers. There's also going to be a cap on compensation for those dismissed unfairly during that initial period. So how long will the initial period be? Well, the draft legislation currently refers to the period being between 3 and 9 months. The government preference is for 9 months, and it's stated it's been referred to as light touch process, government trying to reassure business. But business, or a lot of business, is not particularly happy with this. The CBI again saying that they believe it will lead to an increase in litigation as parties litigate over this probation period mechanism and how probation dismissals are handled. And that in itself, the CBI say that for businesses, especially smaller businesses, the cost and time alone in dealing with those tribunal matters will be very burdensome. The House of Lords and business were not convinced that the concept of the initial employment period went far enough to allay employer fears. So there was a proposed simpler solution, which was just to reduce the current qualifying period for unfair dismissal from 2 years to 6 months, making it a day 180 unfair dismissal right. But that's been rejected. So that will not be coming in as the alternative. Next slide, please, Tom. The second point I wanted to touch on is the ban on 0 hours contracts, although this was very quickly diluted by the government from a complete ban on 0 hours contracts to ending the exploitative use of 0 hours contracts. Again, a fairly controversial area because of the balancing act which has to take place between the need for business to have flexibility and the potential exploitation of workers because of a lack of job certainty and security. So as it stands, the implementation of this concept works around the right to guaranteed hours based on a reference period. So if you are a worker on a 0 or low hours contract, then after the relevant reference period, you will be offered automatically a permanent contract reflecting those average hours from your reference period. But major issues and concerns remain. One of the main ones, and 77% of businesses, again through CBI survey, say this, they think the reform does not take into account seasonal peaks in demand and will lead to guaranteed hours contracts that can't be sustained all year round. So that remains one of the major concerns with this concept of guaranteed hours contracts. We also had debate and discussion in Parliament around whether agency workers should be included, and that landed in a place where agency workers will be included in this new regime. There were concerns that if they weren't included, that the use of agency workers could then be seen as a means of getting around this new regime. So in the end, agency workers were included. There was also discussion and debate through Parliament around whether the right should be to a guaranteed contract or just a right to ask for a contract of guaranteed hours. The House of Lords put forward a proposal that it should be a right to request, but again, the House of Commons and the government essentially rejected this proposal last month. So it will be a right to a guaranteed contract of hours. So what about the low hours threshold period? Well, again, at the moment, we don't know what that low hours threshold will be. The suspicion is that it will be 16 or 20 hours. It should also be noted there are anti-avoidance provisions in the bill, so that you can't just manipulate the hours as an employer or end user to avoid the obligations. There will be limited circumstances in which the offer of guaranteed hours can be made on a fixed term basis. And also there will be protections in relation to the right to receive reasonable notice of shifts, changes in shifts and cancellation of shifts, with payment being due to the individual if things are changed too late in the day. Next slide, please, Tom. So the third point I just wanted to touch on in this bite-sized session is trade union reform. Again, a significant area of change, and 2 points I wanted to highlight and consider. The first is around industrial action balloting. So essentially ballots for industrial action such as strikes. Industrial action currently needs a 50% turnout of those eligible to vote for it to go ahead. Removing this threshold means that strike action can be called where there is a minority of militant members and a majority of apathetic members who don't turn out to vote. The House of Lords proposed reinstating the 50% turnout threshold, but again, the House of Commons, essentially government, rejected this last month during September. So the removal of the threshold stays. What does this mean? Well, again, businesses and trade bodies have concerns that this will increase the number of strikes taking place. CBI again highlights that we do have strike action, industrial action on a regular basis. So the current system, they say, does work. We've seen such as the strikes in the medical profession and bins, etc., across public services, that strike action does happen. So they say the current system works, but the government have rejected that, and this threshold could mean an increase in industrial action. The second point to touch on here is around trade union recognition. So at the moment, to force statutory trade union recognition, at least 10% of workers in the relevant bargaining unit must support those proposals, must support the process. The new legislation will give flexibility for that figure to be reduced down to just 2%. And then having gone to the CAC, which is the regulatory body which governs whether or not recognition will be granted, currently 40% of workers in the bargaining unit must then vote in favour of the proposal. The new legislation would remove that threshold and would just work on the basis of majority voting. So in short, the consequence is that it will be easier or potentially easier for the trade union to be recognised in an organisation, potentially against the will of the vast majority of the relevant bargaining unit. The trade union then has the right to be consulted about contractual terms and conditions that apply to all of those relevant workers. And the CBI has again commented that this threatens to impose unions on workforces where only a small minority want them, and in turn may undermine firms' confidence or business confidence that a union that achieves statutory recognition truly represents its workforce. So again, it remains a contentious issue. These, on the slide, are two of the big or the main issues or reforms in the trade union area, but there are, and I'm sure many of you are aware, additional changes, including trade union rights of access and agreed access agreements to workplaces, including digital access, and there will generally be increased visibility of trade unions in the workplace. Next slide, please, Tom. So, touched on three of the key areas, and in terms of potential action points to take away. Day one unfair dismissal rights. Many organisations are looking at their recruitment processes and how they could be improved. The general principle being that if you improve your chances of getting the right people through the door in the first place, that's going to mitigate the prospect of having to manage the new probation system and the risks which come with that. A lot of organisations we are talking to are also talking about training or refresher training for managers in those recruitment processes, and also performance management, so that when the employment relationship starts and that probation period starts, that they are up to speed and on top of managing the probation process and performance. And as I said at the start, we have time to do this before the new unfair dismissal regime comes into force. Quite a few of clients I've spoken to recently have said, look, we do have already a probation process, probation documents in place, but we don't particularly use them or use them well. So opportunity to visit those, and then as the new detail comes our way, those can be adapted accordingly. For 0 and low hours contracts and the new guaranteed hours contracts regime, I mean, much will depend on how much this impacts your business. But for a lot of businesses and organizations, there's an assessment to be done about what the impact will be on that regime and considering alternative operating models if needed. The devil is in the detail in relation to guaranteed contract hours. So again, understanding what the law says and requires, and then how that may impact your business before decisions are made is a potential takeaway. And then in relation to trade unions, again, I've spoken to several clients very recently about industrial relations strategy. And this is now applying to a wider range of organizations. Do they have an IR strategy which takes into account the new laws, the new regime, again, the potential impact on them, whether they have an existing trade unions or whether they feel that a trade union may be making steps to have involvement with their organization, or whether in fact they feel comfortable that there is no potential move for trade union involvement, but they want to look at their existing employee representative bodies. And that's the second potential takeaway here, is that, do you already have staff forums and employee representative bodies which could be developed? They work well, but they could do more, in which case it may alleviate potential approaches from trade unions if that is something that you wish to consider. Next slide, please, Tom. So there we go. I have managed to stay within the 20-minute threshold that I was given, actually with a few minutes to spare. But as stated at the start, we are happy to take questions. There's contact details on screen if you want to pop any questions through. You will receive a copy of these slides and the recording, and the QR code on screen and on the slides that you'll receive will take you to the page of future sessions, which will be delivered by my RIPE colleagues. Thank you for joining this morning.